Hello, everyone. Happy Friday. Happy Friday. Today is Friday, May 22nd, and it is the beginning of Memorial Day weekend. So exciting. A little different this year due to the COVID pandemic, but we will make the best of it, right? As we should always try to do. Um, I wanted to read today's affirmation, which I think is very applicable today in today's current climate. And it says, I live in the now and I am wide awake to opportunities as they present themselves. So true, right? So if we just practice on focusing in the moment, you will be better adept to deal with anything that's coming your way and maybe not worry so much. And that applies to your personal life, your family life, with kids, with work, and with anything else that you have going on, right? So good words to live by. And that calendar, by the way, is Louise Hay, and she has a 365-day calendar with every day has a different affirmation on it. Sometimes you'll see me post on my Facebook page, daily affirmation from her. So that was today's affirmation. If you're just joining, the affirmation for today is I live in the now and I am wide awake to opportunities as they present themselves. So awesome, right? So anyway, this week has been so interesting. I've had a few consults on estate planning, and I think this crisis has brought this brought to light your personal affairs, right? What would happen if something happened to me? What would happen to my kids? What would happen to my surviving spouse? All of those things. People have a lot of time to think now, and I think that because they have that time, they are getting their affairs in order. And so last week we went through the 4 or 5 main documents that you need while you're alive, because as I described last week, estate planning is like a 2-part process, right? So the first part is dealing with your affairs while you're alive, and then the second part is dealing with your affairs when you're gone. And so every person, usually 18 or older, needs to start thinking adult like, right? So what would happen to me and what would happen to my kids if something were to happen to me or my spouse or my family, right? So I wanted to just cover a few basics. Some people may not even know, but what a will is, right? So a will is just a legal document that states what your wishes are when you've passed, what you want to happen to not only your property but also to your kids, right? So if you have minor children, a will would appoint the guardian of your minor children. And so a lot of clients come to me and say, well, I don't really have too many things. Well, the biggest asset that you do have, if you have children, are your children, right? So you want to make sure that you direct, in case something were to happen to you, who would take care of your kids. And a will does that. You can appoint a guardian in your will. And if you don't, and you pass, and you don't have another parent, the courts will decide who will take care of your children. And I don't know about you, that's not something that I would want to entrust a court to do. So, advise all of you to, if not me, if you're in Florida, you can consult with me. If not with me in Florida, another reputable, capable attorney. If you're outside of Florida and you want to call me, I can recommend attorneys for you to work with in other states. So that's number one. What is a will? The next question to that, I guess, is what happens if you die without a will? Does anyone know what happens if you die without a will? I'll see if anyone wants to type in here. All right, I don't think anyone's typing. So, if you die without a will, it's called dying intestate. Intestate, right? So, if you die without a will, the your property will pass according to the intestacy laws in your state. So every state has their own sort of succession on how your property will pass. So you'd have to consult with an attorney, or you can look up the statutes on your own in your own particular state. In Florida, there's specific hierarchy on where it goes. And so I don't think you'd want that to happen either, right? So my advice to everyone is to, at least on the very basic level, have the documents we talked about last week, which I like to refer to as the disability documents. And then at the very basic level, have a will for when you pass. Okay. And we have someone typing probate. Right. So probate is the process of where your will is, where your property is in persons that if you have children, is distributed the way according to your wishes, right? And probate can be a costly process. It can be a long process. And it's again, something that's not in your control or your family's control. Obviously not your control. You're not alive, but it's not in your family's control either. So, and I don't know how courts are necessarily in other states, but in Florida, they're not fast. So if you can avoid the probate process, I would recommend doing so. How do you do that? Well, there's strategic things that you can do to avoid the probate process, by beneficiary designation or forming a trust where you make sure that things aren't titled solely in your name. And then you wouldn't have to go through the whole all-consuming probate process, time-consuming probate process. And people say, well, who should draft your will? Can I just draft my will myself? You could. You could draft your will yourself. Do I recommend that? Absolutely not. I recommend that you have an attorney draft your will, just to make sure that it's done according to the requirements of your state. Okay. So each will is state specific. In Florida, the requirements for will is obviously it has to be in writing, and 2 witnesses have to witness your signature. And surprisingly, it doesn't have to be notarized. It does not have to be notarized. I recommend, and when I do my clients' wills, they are notarized because it's called the self-proving affidavit. And when you have that attached to the will, you don't have to authenticate the will. It's presumed that you were the one who signed it. There's no big process that you have to do because 2 people have witnessed it and it's been notarized. You can Google that. It's called a self-proving affidavit. So all my wills have that at the end. I'm not sure about other states. Again, I'm speaking specifically for Florida. And so yeah, definitely recommend you, at least on the very basic level, getting the 5 disability documents. Again, those are the durable power of attorney, the healthcare surrogate, the living will, and the HIPAA release. And the 5th one is if you have minors, I would recommend a healthcare surrogate for minors, for your children. Why would you need that? Well, say you are unable to be reached, or your kids are on vacation somewhere else and you're not there. If something were to happen to them when you weren't there, who would they be able to call to be able to guide those healthcare decisions for your minor children? So you definitely should have one of those in place if you have children under the age of 18. And then another question that I get is, so is there going to be a big will reading when when I pass or when my relative passes? When's the will reading? And so it's not like on TV. There is no big will reading like that, and everyone sits down and it's read. It's not like that. So that's just, glamorized for TV. But let's see, we have a question here. Can I do divorce proceedings? So I personally don't do divorce, but I have a wide network of attorneys I work with, so I can refer you to someone. If you just call the office number, I can definitely refer you to capable family law attorneys to do that for you. All right. And the last question I get is, well, I need to make a change to my will. Obviously, you can change it up until the point that you die, and all you do is don't take your will and then cross out things and make changes that way. That doesn't count. It could actually lead to people thinking, hey, someone tampered with it and it wasn't the person whose will it actually is, right? So you can make changes to it by but from what's called a codicil, right? It's an amendment to the will. And I would again advise, if the original attorney is there to do that for you, to contact them to have them do the codicil for you. And so, yeah, so even a very basic will, if you don't have a lot of property or you don't have a lot of things titled in your name, it'll go, those properties and those things will pass outside of probate, those assets. And if you have a trust, the will is just a formality if everything is named and labeled in the name of your trust. Okay. So again, that's all state specific. So you would want to contact an attorney in your own state for that. Does anyone have any other questions on that process? Oh, while I'm waiting to see if anyone has any questions, where should you store your will? Where do you think you should put your will? Does anyone know? So usually, there's one original will with original signatures. Where would one store that? Do you think it's a good idea to store it at the bank in your safe deposit box? All right, someone said safe deposit. The answer to that, my recommendation, and I think a lot of attorneys would agree with me, is no, I would not put it in a safe deposit box. Why? Why do you think you shouldn't keep your original will in a safe deposit box? So I'll just answer that. Why you shouldn't is because who usually is the only one that has access to that safe deposit box? Usually it's the owner of the box, right? So if the owner of the box has passed, then you have to get a court order to get into that safe deposit box, right? Again, time. That takes time. So the best thing to do is not to put it in your safe deposit box, because it may take a while for someone to be able to get in there and access it. So my recommendation is that you store your will along with, your other estate planning documents in like a fireproof box at home. And you don't need some expensive fancy binder and all the bells and whistles that some people try to sell. A basic binder is fine. The way that I do it is I actually do folders, and you can put in there tabs and organize it nice and neat. That way someone, if they're looking for a particular document, it's very easy for them to find. So a fireproof box in your home. And then you'd want to give copies of those documents to the relevant people. So for example, your healthcare surrogate, you'd want to give copies to your doctor, right? Or the person who's named the healthcare surrogate, just in case something were to happen, they have that copy. You can also ask your attorney to provide you electronic access to those copies as well. That way, if you're traveling and you don't have that paper with you in your hand, you can have them pull it up wherever you're at, whether it's a secure link or whatever your attorney has decided for you. But sometimes people don't always have that paper copy with them, so it's a good idea to have electronic access to it as well. All right, so that's what I suggest for those documents. So definitely don't keep it in your safe deposit box, and keep the originals with you at home. And I think I said it last time. If it's not in a fireproof box and you just have it, maybe on your bookshelf, try to make it stand out from the other millions of books or documents or binders that you may have. That way it's easy to locate, right? Because the whole point is you don't want to make it difficult for people to access. All right. And then how often should you review those documents? So years ago, when I first graduated from law school, I worked at a private bank, and I worked in the estate administration department. And that was interesting. Besides it being interesting, the clients, they would review their wills every 3 to 5 years, for the most part, or if there's any big life change. So if there's a birth of a child or divorce or moving out of the state, any of those things you'd want to review as well. So, but it was interesting working in the estate administration department because I was actually working on the other side of it, meaning that I wasn't actually doing the drafting of the wills and the trusts, but I was administering the estate after. And so, if I've learned one thing from working there is that you definitely want to make sure that you make your wishes clear while you're alive, because there was so many instances where people would phone and people would call and say, well, so and so said they were going to leave me this, and so said they were going to leave me this, and that wasn't the case. So you want to make sure to lay out your wishes very clearly so that there's no confusion when you pass, because I think that most people would agree that, it's sad enough that you're gone, right? Your loved ones will be sad when you're gone. And to add on top of that confusion in the estate distribution process and all of that wouldn't be an ideal situation. So just something to think about. I know for me, with my clients, it seems like sometimes it takes a while for them to return the questionnaire or, sort of ask questions once we've done an initial consult. And I think probably because it's hard to think about. It's these issues, thinking about your own mortality or thinking about your own kids and you being gone is not the funnest thing to think about, right? Even for me, when I was doing mine and thinking about my son and me not being here was sad, right? But was sadder to me, and which prompted me, to move on it, was, him being taken care of by someone maybe that I wouldn't want him to be taken care of, right? Or someone that the court appointed that I didn't necessarily think would not have thought would have been the best choice, right? So a little bit of planning now can save a lot of heartache later. So that's what I really advise. So you can call my office. I think the number's appearing on the screen there. It's 407-476-5320. And I'm going to type in the comments here, my website, because you can always go there. It's an interactive site, so you can go there and schedule an appointment as well. It should be, there it is. And then if you also want to send me an email, you can email me here as well. Whoops, hopefully that went through. I think it just erased. So I'm using this new platform called StreamYard, and so it's streaming from one place directly to Facebook. So there's my email there. All right, I'm seeing I'm getting any messages here. Okay, so and I also, if you have any personal injury cases, whether it be a slip and fall or a car accident or anything like that, you can always call my office too, for those cases too. Again, in Florida, for any of those type of cases. Okay. And then finally, I just wanted to talk about, I received a couple of questions on immigration, right? So I'm going to read the question and then go ahead and answer it. So let me just pull up the question here. Okay. So someone asked me, and again, I don't know, this is not country specific, but it says, my husband is a permanent resident and he filed an I-130 for me and it's been approved. I live in the US. May I apply for adjustment of status now? Yes. So if you're in the US and you filed a petition for your spouse, and that petition, the number of the petition is an I-130, and they are here in the United States, absolutely, you can go ahead and file for adjustment of status because they're in the United States. So you can only adjust, meaning change status while you're in the United States. If they were overseas, you would do what's called consular processing, and you would do that at the embassy in whatever country you're living in. So if they're within the United States and you file an I-130, you can go ahead and adjust if it's been approved, or you can do both at the same time. You can file the I-130 and the I-485, which is the actual adjustment application, at the same time as well. And I handle those. I would love to do those. I mean, most of you know that I'm an immigrant myself and went through the whole process, and it was so rewarding. And I love being a U.S. citizen. I mean, I love my country too, but I love being a U.S. citizen. And so it's so rewarding for me to be able to do that for my clients as well. All right, so that was question number 1. And then the other question I got, let's see here. So it kind of goes along with the question I just read. So this person said, I just got my green card. Can I have my wife, who's living in China, adjust her status? So based on what I just said, obviously you all know now the answer to that is no. She can't adjust if she's living there. She can do what's called consular processing so she processes everything over there. And does her interview over there. Actually, the documents are sent to the National Visa Center, but she does her interview and everything there, and then comes here. But she can't come here. Well, she could come here, I guess, on another visa and then adjust here once she's here if she'd like to do it that way. But since she's already there, and if she doesn't have plans to come here, then you would do the process over there, and that's called consular processing. Okay. And then the third question I have that I received, it says, I came to the U.S. with a K visa, fiance visa. So again, the immigrant and non-immigrant visas, we assign letters to them. We refer to them by letters, and so the fiance visa is called the K visa, and it says, but I married somebody else. The person I married is also a U.S. citizen. Can I adjust? No, you have to marry the person who petitioned the K visa for you. So you cannot adjust if you've married someone else who did not petition for you, right? So, and usually you have to marry that person. For example, if someone petitioned for you on a K visa, you have to marry within 90 days of arriving to the United States, okay? So you have to marry, and then if you do it that way, then you can adjust. So you marry within 90 days of arriving, and then you can adjust. But it has to be to the person who petitioned the K visa for you, right? So if you think about it, it sort of defeats the purpose of the K visa. If you have a fiance, they apply for you, you come here to the States, and then you marry someone else. Someone said, can't believe people use to get, yeah, I know. I mean, sometimes people say lawyers become cynical from seeing these type of scenarios, and but I always try to maintain a positive attitude. Those who know me know that I really, really try to always maintain upbeat, affirmative, positive attitude. But there are always going to be some bad apples like that, and so, but that doesn't take away from the general good of the population, right? So I hope that answers that question. And I think that's it. I think that's all I have for today. I like to keep it under half an hour to keep everyone's attention. Yeah, so thank you. Yeah, I really try to maintain a positive attitude. And, quite frankly, if you're hiring a lawyer, I think that let me just speak for myself. So I'm going to be concerned with not only your legal process, but how you're doing generally. So hopefully everyone's doing well and staying positive and healthy and well during this pandemic. My little tip is to make sure you're drinking enough water and eating fairly healthy. Because all those really affect your mindset, right? So if you try your best to do all of those things properly, then usually your mental state sort of reflects that, right? So it's kind of like a direct correlation. So for me, I try my best to eat well, drink well, stay hydrated, and all those things, because especially during this time where I'm not out and about as much as I normally am, I want to do the best that I can with to keep my mental state good, right? So I hope those answered all of your questions, and I hope everyone's doing well. You can always email me. You can always call me at that number, on my office number, if you wanted to schedule a consult, or you can go to my website directly and do it there. There's 2 places where you can schedule a consultation on there. All right. So I hope everyone has a wonderful Memorial Day weekend, and I will be back again next Friday, God willing. All right. Have a good weekend, everyone. Bye.